it's not there yet. Yeah. Foot rise.
Yes, Mr.
My lord, my lady, over lunch, and I've managed to get the Town Council Panic 1947 and the original text of the 1972 Act resolved, and just hand those over.
Thank you so much.
So section 42.
It's just a general power for local authorities to appropriate property. I mean, almost in a sort of compulsory purchase way, to comply with the development plan.
Yes.
And that was Mr. Justice Goff's problem, or the problem in that case, and that was there was no development plan for 20 years.
Yes.
So
still a problem today. Something.
Yes. So they couldn't get the consent of the minister because they hadn't got that precondition.
And so, I mean, appropriate doesn't necessarily mean acquire in that sense. It could be land you already hold. You just take a formal decision to say we now hold this for housing or education or whatever such purpose. So that's the way it was done, rather than straight to disposal. You have to go through the prior process of taking that conscious, deliberative decision, as it's put in the Goodman case, to appropriate. And then the other legislation that's handed up is the original 1972 Act when it was passed. And one can see the differences on the fourth page in section 123. That's subsections 3 to 5. And they called it public trust land.
That's interesting.
Which is defined, and in fact the definition wasn't repealed, so it's still hanging in the current version, but doesn't define anything that's actually in the Act. But public trust land, they called it. And what the Principal Council could do at that point, and again, Section 127 was there to transpose that to parish councils, was dispose of land, but it had to be under 250 square yards, and they had to cause notice of their intention to do so by advertising in the newspaper. So it was a much more limited power of disposal. Then you have the short tenancy point at 4, and subsection 5, another power that's also been repealed now. And so then 127 is much the same in transferring that, and then 128 obviously has also been amended in light of the amendment of 123. And then 131 has been slightly amended. You'll see that at the end, we haven't got there yet. So that was really just for historic interest.
Thank you.
Way.
Yeah, that's helpful to have.
Evolution. The point we got to was on construction of section 128. I found the case that escaped me for a moment, which was the Barnet Football Club case, which is at tab 35. And the relevant part of it, or the relevant paragraph in the judgment of Mr. Bompus QC, is right at the end, paragraph 61 to 2. So this is, apart from structure deed, which I'll come on to next, the only authority, well, and the earlier Coker case, but the only authority directly on 128 subparagraph 2. Now what the judge in this case thought was subsection 2b, in contrast with subsection 2a, does refer to both classes of person, so that's those claiming under and those dealing with the authority. the distinction, it seems to me, is between those who are currently in the
Sorry,
course
which paragraph? Forgive me, which paragraph?
Sorry, 162.
162,
It starts
right,
at 161,
okay,
and then
okay.
the most important bits are 162. So those who are currently in the course of some transaction which will lead to a disposal, and those such as holdings in the present case who already have the benefit of a completed disposal. The former, it seems to me, are those dealing with the authority, in contrast with subsection 2a. So 2b, in contrast with subsection 2a, is apt to include persons who have not yet had the completed disposal in their favour. The purpose of the subsection is to absolve those persons, as well as persons with completed disposals, from any need to be concerned about the question whether the relevant consent was required or obtained. So that was what was in my mind when answering my Lord's
I wonder
questions.
whether that...
But it doesn't sit with Shropshire Dean very easily,
No.
as my Lord anticipates, because the point in Shropshire Dean, Mr. Justice Elias's judgment, is that section 1282 only refers to a situation after a disposal has taken effect, and so that construction doesn't seem to align with what Mr. Justice Elias thought.
Was this case of Mr. Bumpus's referred to in Shropshire Dean?
I think it was subsequent to it, but I don't think
I think you're right. But so I suppose, but Shropshire Dean wasn't. It was cited to Mr. Bumpus.
Yes.
Sorry, I see.
Referred to in paragraph 1.5.
Hold on. Yeah.
He doesn't seem to have picked up that
Shropshire
nuance.
Dean. Justice clearly thought that 1282 was equally applicable, where what was disposed of was a freehold, the grant of a lease. But yes, he doesn't. Yeah. Mm.
Now, having thought about that point, then I could offer one further thought on the possible construction of section 128 in light of just taking Shropshire Dean as authoritative. So, Mr. Justice Elias decides in Shropshire Dean, which we've got, so it's tab 26, that section 128 applies only after the disposal. If I could just ask my Lords and my Lady to look at 128, which is in Shropshire Dean, quoted on page 332 of the judgment.
Just give me a second. Shropshire Dean as a tab
26.
Thank you, sorry.
And then on the
I've got it here, that's why.
page 332, section 1282 provides and sets it out.
Yeah.
And I think it's important to understand, when trying to understand B, the preface to that in subsection 2, which is that where under the foregoing provisions of this part of this Act or under any other enactment, whether passed before or after at the same time as or after this Act, a local authority purport to acquire, appropriate or dispose of land, a person dealing with the authority or a person claiming under the authority shall not be concerned to see or inquire whether any such consent has been given. Now, the whole issue was, is it before or after? It's only after disposal, so it must follow that it would only be after appropriation as well. But after appropriation, so the council says no longer going to use it for open space, it's going to be housing land, a person would not then be claiming under the local authority, because that wouldn't be the circumstance, but they would be dealing with them if, for example, there are circumstances in which they could then be dealing with the local authority. So it may be that the term dealing with there is to ensure that you're not limited only to people claiming under, because where appropriated, no one would ever claim under the local authority, because it would still be vested in the local authority. And so in the Shropshire Dean type situation, where a contract for sale is entered into, but not a disposal, the person with the benefit of the contract doesn't have to inquire into whether the local authority had appropriated the land for that purpose in advance. They can take that as read. And so the validity of their contract for sale can't then be impugned, just as their title can't subsequently be impugned after a disposal. So that may be the function that dealing with is serving. Instruction. My Lord looks perplexed.
I'm just wondering, trying to work this out. Just need to remind myself of Shropshire Dean.
Yes,
Was there a condition
2.
There wasn't no, it wasn't the case where there was a condition requiring compliance. It was silent, wasn't it, about the statute?
Yes. So there was a decision to sell some flats to tenants in Hackney at basically it's an undervalue, and then a prospective purchaser immediately upon discovering the decision before a disposal took place put in a higher bid.
Yes.
Got an injunction stopping the contract for sale being fulfilled, and then challenged by judicial review the breach of fiduciary duty involved in the contract for sale.
Yes.
And the outcome of the judgment is that the challenge, because of breach of fiduciary duty, wasn't
wasn't
prevented by
this.
Section 128, even though other matters might have been. Then the question was, when did Section 128 apply? And under the holding, we see on the front, on the frontispiece, the entry into this contract with the tenants did not constitute a disposal within the subsection. So, Mr. Justice Elias, it's only after the disposal that Section 128 bit. So at that point of contract for sale, they didn't have the benefit of Section 128, and so.
On your submission, why didn't they have the benefit of 128(2)(b)?
Because there hadn't been an appropriation here. But it had.
We're not concerned with appropriations, are we?
No, but we are in Section 128 generally. So I'm just talking about the construction of Section 128 itself.
Sorry. Well, we're talking about acquiring, appropriating, or disposing.
Indeed. So I'm giving the example of.
We're concerned here with a disposal.
Yes. But I'm trying to illustrate how the dealing with phrase can be pertinent, because some people will be in situations where they are dealing with but not claiming under, and never will be claiming under.
That's clear. That is clear from the language of this. But I mean, B is not limited to cases of appropriation, is it?
No, I'm not suggesting it is.
All right. So it's concerned with. I mean, we can forget about acquiring and appropriating, can't we, for our purposes?
Well, I just think it's helpful to try and understand why it's meaningful, not to just say claiming under.
Do you say do you say it has a meaning in respect of the disposal of land? B, I mean.
Well, in light of what Mr. Justice Elias held, that the protection of Section 128 only applies after disposal already, then a person claiming under would be protected by 128(2)(a), because the disposal would have taken place. And so a person dealing with would have to be somebody who wasn't claiming under,
I see,
but was attempting to negotiate some other form of contract, as the case may be.
Yeah, so the two are mutually exclusive. If Mr. Justice Elias is right, then subparagraph B can only apply to appropriation or acquisition. Or does it apply at all?
I mean,
It's rather difficult, isn't it?
Well, unless it applies to, yes, because once the local authority had disposed of it,
it's not going to give any protection.
It's not going to be dealing with anyone anyway, because it wouldn't have the land.
Right.
Well, I suppose it could have disposed of it, not the freehold. It could have disposed of a lease or a right over land, and the person then is not claiming.
Well, no, but that's a disposal of land, isn't it?
Yes.
All right. Okay. I mean,
yes. So
I think I would find it difficult to see that. I mean, given the way it's drafted, it looks as if the drafter thinks that A and B apply to acquisitions, appropriations, and disposals. But if one were driven to say it applied only to one or two, but not all three of those, then that's the conclusion at which one would have to arrive. But it's not a natural reading of the provision.
Yeah. I mean, a scenario where my mooted construction would apply to a disposal would be something like a disposal of an option, which is one of the issues considered here. So that is a disposal of land.
That runs into the Mr. Justice Elias point, assuming he's right, doesn't it?
Yes, but
you still wouldn't be able to enforce the option. Just as instructing, they couldn't enforce the contract. Is that right?
No, they could enforce it. That's what 128(2)(b) would ensure.
Well, but didn't he say
So the person dealing with the person, they wouldn't be claiming under because they just have an
No,
option.
but the problem I have is why weren't the tenants or whoever it was instructed in within B?
Because they had a contract for sale which wasn't a disposal of land within the definition.
Well, that's the same with an option.
No, it's not, because an option has been held to be a disposal of land.
An option, but not a contract.
Yeah.
Can't be right.
That was the issue. That was the issue that Mr. Hobson was arguing in Shropshire, unless I.
But an option is just an offer which you're required to keep open.
Paragraph 24 of the judgment, my lord.
24.
Yeah.
Hobson relies on this dictum.
So he's referring back to the judgment in the Chippenham Golf Course case.
So Lord Justice Scott expressed the obiter view that section 123 widens the power of local dispose of, yes. Oh yes, but that's right. But so is a contract. It's a disposal of an interest in land.
Well, not
I mean, an option is one stage further away from a conveyance than a contract is.
Well, that was Mr. Hobson QC's argument in front of Mr. Justice Elias. Mr. Hobson relied.
No, they're talking about whether it's a disposal.
Yes.
And Mr. Justice Elias says no. Disposal means disposal of the legal title, because a contract disposes of the equitable interest.
It comes back to the fact that a disposal of land includes an interest in land under section 270.
Well, I think maybe your strongest point is this: that A is referring to a person claiming under the authority, and B is a person dealing with the authority. So you're claiming under the authority if you're the successor in title, for example. B is broader, person dealing with, and the issue really is, as my lady says, are they mutually exclusive? So you're not a person dealing with the authority if you are a person claiming under the authority. You maybe
That's
don't put
certainly
it that
true.
way.
If you're claiming under, you certainly don't need to be a person.
We have the problem as to how we
Yes.
deal with B, and your short point about B is that it's trying to just get a handle on this. You say it deals with someone who hasn't acquired an interest in land, but is nonetheless dealing with the local authority in some way, short of acquiring an interest in land. Was that fair or unfair?
It does come back to the structured in circumstances. A person can be dealing with the local authority. For example, because an option to purchase qualifies within the statutory terminology as a disposal of land to them, but they are not claiming under the authority. So I hope that makes sense.
So a person deals with the local authority if, for example, they have an option to acquire the land. Is that it?
Indeed, or any other interest or right which is not tantamount to claiming under. So claiming under refers to people who are claiming title under, but you can have a disposal to you of something that you're not claiming under.
I mean, that's your ball point, isn't it? Although we're struggling to work out people who might be dealing with, in A, a person dealing with the authority is not included in A and is included in B. Whatever that means, and we're struggling slightly,
so,
whatever it means, so B adds something to A. We're not quite sure what at the moment, but something.
Yes. I think that's as far as I can help on the statutory construction in terms of any authority.
Right.
The other question my Lord posed before the break was whether the obligation transfers, i.e. the whole of the trusteeship.
Yes, the statutory trust, shall we say.
Yes, and that's why at the very outset, in response to my Lord, Lord Justice Hickinbottom, I was quite keen to ensure that the two components of the statutory trust, both the obligation and the rights under it, are understood, because we are dealing here with a sui generis form of statutory trust, and so
Yes.
the way in which this operates following a dispose is not actually, it's not, as the judge below found, not guided by private law principle necessarily, so we are in a sui generis
No, I think certainly
situation.
not.
At its boldest, my contention, and was the contention below, is that following a disposal whereby the section 123, 2A and 2B conditions have not been followed and therefore the trust hasn't been discharged, then the trust remains in place. And so that means both components, the rights and the obligations. And the way I put it below was that that's no different, and the court shouldn't shrink from an analogy to a village green, where the freehold title passes, the recreational rights still pertain, or indeed a public highway.
So the members of the public still have the right to use this amenity space as amenity space, and the obligation to allow them to use it as amenity space remains with the town council.
No, sorry, that would then pass to the new owner. So that's the bold submission. But the lesser submission, which aligns more closely to what the judge in my submission was getting towards, is that the recreational rights persist, but not the duties. That's the alternative way I put it. And that then accommodates the tricky situations I flagged before lunch of a disposition of quite an insignificant interest in land or a short tenancy, not then extinguishing for all time and all purposes the recreational rights of the public over that land.
It is quite difficult because there are quite a lot of highways and byways in this argument. That's not a criticism, but there have been. But the trust we're talking about, the obligation that we're talking about, is the obligation which arises under Section 10 of the 1906 Act, or alternatively under the other acts by analogy.
Yeah.
And that obligation, firstly, is on a local authority.
Yes.
That's upon whom the obligation is. That's upon whom the statutory obligation is.
Yes.
Nowhere is the suggestion that that obligation can be borne by anybody else.
No, that's exactly.
Secondly, and this is something I'm struggling with, but it's not the only thing I'm struggling with. At the time of Section 10, and for decades afterwards, the acquiring any estate or interest in or control over any space, which is those are the words of Section 10. A local authority who have acquired any estate or interest in or control over any open space, and then it's got the obligations which are to hold and administer the open space.
Yes.
For recreational purposes, and maintain and keep the open space in a good and decent state. But at that stage, we know that holding, once you've got the interest, once the local authority's got this interest, it can't get rid of it.
Yes.
So this is drafted on the basis that the interest in the land and these obligations go absolutely hand in hand, because there is no way you can get rid of the interest. The difficulties arise when you could get rid of the interest. First, I think, under Section 42 of the 1947 Act, appropriation under that Act, but that was going to happen many times. That was the first instance. And then under, I think, the 1959 Act, which allowed ministerial consent.
Section 29.
Sorry, Section 29. And it's that where these issues start to arise. There are no issues before then. And it's whether the interest and the obligation still go hand in hand. So if you get rid of the interest, the obligation automatically goes, or whether they can bifurcate and go their separate ways, which is what you say they can and do.
Yes, I do say that, and I say that the advantage of that reading of the subsisting right is that it is more consistent with the intention of the legislation. Why have this mechanism for consciously discharging those rights if the effect of disposal is by automatic operation of the disposal to discharge the rights in any event? And so that's why I light upon this word subsist that the judge below used, because she clearly didn't think, and as I've said in her paragraph 120, wouldn't be consistent with her view that the trust is entirely extinguished insofar as it manifests as recreational rights for local people. And so those do subsist. And the advantage of looking at it in that way is that if circumstances change, so take my short tenancy example, once the freehold reverts, then the local authority can continue in its duties under the Act to hold and administer under Section 10, or as the case may be under the 1875 Act. And it's worth picking up the Naylor and Essex case, because that's the one, it's at tab 36, that deals with Section 9 of the Open Spaces Act. And in Naylor and Essex, the statutory trust pertained because although the land was in third-party ownership, i.e. not...
I'm sorry, I was...
Yes, sorry.
Which case?
So it's tab 36,
Thank you.
John Howell QC's judgment in Naylor and Essex. And this was a claim all about registration of a village green. And there's a whole line of cases now that where land is held under statutory trust, rights aren't acquired by prescription because they're not adverse, they're by right rather than as of right. And so these issues come up in that context quite a lot. So this was the context. And in this case, at paragraph 50, so if we start back at 44, we see that John Howell QC refers to the 1906 Act at 44 and refers to Section 9 of the 1906 Act, and he sets that out above. Now, Section 9 is a power for local authorities, 9b, to undertake the entire or partial care, management and control of any such open space, whether any interest in the soil is transferred to the local authority or not. So Section 9 is a power to manage open space that's in private ownership. And then he considers what the impact of that was. He says, I've set out Section 9 and 10 above. Dr. Bose submitted that the local authority may act under 9b of that Act if it has first acquired an interest in an open space under Section 9a. So it may only do so, which it had not done in this case. And then John Howell says at 55, in my judgment, a local authority may act under Section 9b of the 1906 Act, so that's to manage the land, even if it has not acquired any interest in an open space.
I'm lost.
I'm sorry.
Which paragraph are you on?
Paragraph 45.
Yeah, you said 55.
55.
Oh, did I? That's mine. That's no wonder.
Right.
Paragraph 45. The judge held that a local authority may act under Section 9b of the 1906 Act even if it has not acquired any interest in an open space under section 9A of it.
Well, let's just have a look at 9, section 9 again.
Yeah, so it's back at paragraph 17 of his judgment, if that's
Okay.
an easier
Right.
location.
Section 9. Oh,
I don't have any great problem with this. 9A 9A concerns acquiring interests in the land.
Yeah.
9B would be OTOs if it only applied where an interest in the land had been obtained. But this doesn't give the local authority a power to say of a piece of land, well, we like the look of that. We'll start caring and managing it. I mean, it doesn't. What this means surely is that if an owner says, well, this is waste land, if you want to come and make it into a park, that's fine by me.
because B says whether any interest in the soil is transferred to the local authority or not.
Yes. And
So the question is, what light does that shed on section 10?
oh, well, then that's dealt with at paragraph 50 of this judgment.
Right. As he said, he hasn't. Oh, right. Section. He says in 50 that the applicability of a superadded trust, such as that which arises under section 10, if the authority has acquired control.
Yes, and that's referring back to his paragraph 38.
But sorry, what my question really, what does section 9 and this judgment shed? What light does it shed on the proper construction of section 10? I mean, just going back to section 10, and I think we have to have an eye on the clock,
I'm
incidentally.
sorry, yes. Yeah.
If we focus on 10, I find it difficult to read 10 as permitting the trust or duties to be divorced from the ownership.
That may well be right, my lord.
Well,
I'm not
that's
gonna
very
press that any
important.
further.
That's very important because the subsequent legislation, by dint of the provisions we've been looking at, cannot have the effect of amending section 10.
No.
Well, I mean, it could by necessary implication, doesn't do so explicitly.
Can I answer the point on how section 9 illuminates section 10?
Yes.
Because what Judge Howell was saying, and if we go to 38, what he's saying is that the recreational rights that the public enjoy can be enjoyed where the land is being managed under section 9. So what that shows is that the rights that arise under the Act can flow even where land is in third-party ownership.
Well, sorry, yes, but that's right. Yes, okay. I mean, we agree.
And so in this bifurcation, as my lord called it, of the rights and the duties, we can see how the rights can persist. For example, when land passes into third-party ownership.
I don't follow that.
Because even
Because
though the duty under section 10
what
may
section 9 does is to confer a power on the local authority to do a number of things. One is to acquire by agreement, etc. Another is to undertake the entire or partial care, etc., of any such open space, whether or not it's acquired it. Now, but what we're concerned with is a section 10 statutory trust or duty, which, as I've said, seems to march with the ownership. Now, okay, if the local authority disposes of the land, it would have power under section 9b to undertake the entire or partial care, management and control of the open space. But that would be with agreement with the landowner.
Correct.
But it doesn't illuminate, does it, the issue as to whether the duty can continue to exist under subsection 10, notwithstanding the disposal of the land. We're not concerned with whether a new...
That point, no.
And but that's very, very important in this case, isn't it?
Well,
I mean, this goes to the nub, you see, as I see it, as to whether the duty can survive the disposal. Yeah. So we do need to understand your case on section 10,
Yes,
I think.
because if these do march hand in hand, if ownership and the duty on the local authority march hand in hand and cannot be divorced, that would explain why the statutory scheme considers disposal and protects purchasers on a disposal, but doesn't say anything about the duty, because if they dispose of the land, if they march together, dispose of the ownership, you dispose of the duty. The duty goes.
But then if the duty goes, what's the purpose of having a specific statutory presumption, a specific statutory provision, which says that the trust will cease to be in place only if you do a certain thing?
Yeah, I mean, that would be the basis, I think, for a submission of that section 10 is amended by a necessary implication.
I adopt my lady's point, and the other principle at the heart of all of these powers...
Well, I know, you may, I mean, my lady says what would be the point of it, but the question is, where does that lead it? What do you build from that?
So it's a fundamental principle, the judge adopts it, it's in all the authorities, that a creature of statute, like a local authority, can only act in accordance with such powers as they have, and that extends also to discharging a statutory trust. It can only expressly discharge that trust where it has power to do
absolutely.
so.
Yeah.
And so to find that the mere act of disposal by implication discharged it would, in my submission, be to ascribe to the local authority a power to discharge that trust, which is in conflict with what the statute says as to the circumstances and basis upon which that trust can be discharged. Mm. And so one has to get to another sui generis position in my submission, that the question as to where the duty goes is that it does continue to subsist at some sui generis level following an unlawful disposal which has not gone through the proper vires for that purpose.
Right.
And then
So unless section 128 implicitly amends the section that says you can't dispose of the land without publishing the relevant information.
2A and 2B.
You can't confer on the local authority a power to do something, and it doesn't even purport to confer a power on the local authority to do something. So you say, a fortiori, I can't do it by being silent about it or by dealing with the aftermath if it does something that's in conflict. And the only concomitant of that, you say, is that the obligation must subsist in some form or another, even if it can't, in fact, be put into practical effect.
Even if it can't be enforced in the words of the judge below, yes.
Yeah.
And so then my secondary submission, slightly in the alternative to that, is that another way of looking at it is the way the judge below looked at it, which is that the rights subsist and are capable of having impacts in some way, but not of being enforced as against the new disponee, the new owner of the land. And again, that is a sort of modified
Potentially,
lesser version.
potentially, therefore, the public could complain that the council is in breach of its statutory duty and maybe mount some sort of claim against the council for disposing of the land without going through the relevant provisions.
Yes. And so they still have the rights. And then the key
Yeah.
for my argument on this claim is those rights are therefore still material considerations
Yes.
in planning.
Well, just so, I mean, clearly they can complain about what has happened, and it might be the court would make a declaration, be a discretionary remedy, but it might do. But the question is, what if one says that the duty subsists? It's clearly not. There's no duty on the landowner, so there's no question of enforcement against the landowner. But if the duty exists but can't be enforced in any way against the person who owes the duty, namely the local authority, that is a strange outcome, isn't it?
It is in that scenario.
I mean, could it?
It may be less strange in my short tenancy example, because if the rights persist, then once the short tenancy is over, there's still a continued function.
Yeah, I don't personally see any great difficulty with that, but on a slightly different way. But stick to the disposal of the whole interest, because that's what we're concerned with. I mean, would the local authority, if this duty is on it, be under an obligation to use best endeavours to achieve a maintenance of the land as open space? I mean, it can't force that, but it could try and achieve it by agreement. Would you say?
That's certainly the kinds of submissions that my client has been making to the town council.
Would it be undermining? Would it undermine the performance of its statutory duty if it gave planning consent?
Yeah, that's what's going on.
And one issue that my client has raised with the town council is if this duty, the trust has not been discharged, what happens to the money?
Well, never mind about. Forgive me. Never mind about the money. I don't think. I mean, that raises a whole raft of no doubt very interesting questions, but they're not before us, and it doesn't really help because you're not really so. The focus by raising with you is you say the judge says it's totally unenforceable, which seems an odd result, where a statutory duty continues to exist. So just raising with you whether you say that the duty, that there is an extent to which the duty can be enforced. I suppose we come right back to this, that you say, well, if the judge is right that the duty subsists, then it's a matter for the planning committee to have taken account of when deciding whether or not to give consent.
Yes.
Well, if it still subsists, there is some obligation on the local authority, on the town council, which is not the same as the local planning authority.
Yes.
Ah, yes, that's the point. Yes.
There's still an obligation on the town council
Of course.
to do something about keeping it as a local amenity. And so putting on the hat of the planning authority, when the planning authority comes to deal with an application by the owner of the land, who's the lawful owner, and who has no notice whatsoever of this legal conundrum that's been going on in the background, to build his 15 flats or whatever it is on the site, the planning authority then says, yes, but the town council got everything completely wrong, and in consequence of that has found itself in a situation where it is in continuing breach of a statutory trust, or whatever you care to call it, an obligation to use this as open space. And so on the one hand, you've got the, in inverted commas, innocent developer, and on the other hand, you've got the less innocent town council, which is at fault for doing what it's doing. And you say, well, when it comes to looking at the planning considerations, it's not fanciful to suppose that the planning authority, balancing everything, including the NPPF and so forth, would come down in favour of saying, you hoist by your own petard, and we're not going to give planning permission. Yeah. It may not. But what you can't say is it's immaterial.
Correct.
Yeah.
All right. Well, now, I think that's probably exhaust your time on that ground. You've got
Thank you.
5 minutes on
Actually,
on ground 2.
Yeah, I only need minutes on ground 2. The final authority, I won't go to it, was the Coker decision. Miss Justice Lightman's decision is the other one on section 128. Yes. And of course, that's where he establishes the point, really, that section 128 does what it says, but no more than that, which is at the heart of my submissions.
I think we've got your written submissions on that.
And you've got, and
so ground 2.
The persistence of,
sorry, time is very short. You've already had.
Ground 2 is that the small area, the small portion of land, is the access site.
Yes.
There's also, in fact, a footpath, public right of way, comprised in that as well, but it's on the car park.
So the car park, who owns the car park?
That's part of the recreation ground owned by the town council.
Right.
So the car park is part of the recreation ground.
Right.
It's impressed with the statutory.
And you said there's a right of way over it?
There's a footpath that starts from the bottom of the car park and goes up along the edge of the development site.
Well,
do you mean inside the development site? On which side of the boundary?
On the other side of the boundary.
But if it's all recreation land, what's the right of way? I don't understand.
There's also a right of way.
Sorry?
There also is a public right of way.
Maybe it predates. Does it predate the acquisition of the land?
I don't know the answer.
All right, okay.
I don't think it can. But there is, whether it's a right of way or not is a different matter. But there is a footpath, as I understand it, from the top of the car park. So there's the car park, there's a footpath from the top of the car park, which goes up around the site, and it goes on to the school, I think.
Yes.
I see.
But I mean, your simple point is that it's not de minimis because because
It's the access.
It's the access.
Yes.
I mean, that is the point. And access is often very important in planning. I mean, there are many developments which, because you can't access them, are refused permission on that basis because they haven't sought. I mean, access is specifically a reserved matter that in the old outline reserved matters stage, there was specifically a whole statutory concept that had to be dealt with by a planning committee.
But that's looking at it from the wrong end of the telescope. We're not talking about de minimis from the development point of view. We're talking about whether it's de minimis from the recreational ground point of view. The answer still may be yes. I'm sure you'll say it. But it's not whether this tiny bit of land is de minimis when you look at the whole development. It's whether it's de minimis so far as the Section 10 area is concerned.
I understand. I would submit both. So that the interference with the Section 10 area, I say, isn't simply de minimis. But I also say, looking at the other end of the telescope, that the prohibition that the use for recreation of the recreation ground, Section 10 area, could impose on the access would also not be a mere de minimis interference with the planning permission. Because the public rights over the access way can interfere with the ability to access that site. So, but it cuts both ways. If those rights are enforceable, as the judge held. So the HGVs will be interfering with their recreation, and their recreation could be interfering with the HGVs. Well, that's
all right.
Round 2, and I shall leave my submissions there unless there are any further questions and take any other points.
Miss Goodman, thank you very much indeed. Yes, Mr. Garvey.
I'm grateful, my lords and my lady. My lord and my lady, you might note that I'm in court alone today. Those instructing me were very keen I record why that is. Their relevant planning officers have been given a directive by the chief director that they shouldn't travel.
That's fine. I mean, they're able to follow it, I hope, on the live stream.
They are indeed, but they wanted to. I'm sure the court aren't offended, but there was no sign of disrespect that they
No, not in the least. That's fully understandable.
There are a number of factual points I need to clarify that my learned friend has got wrong. There's quite a number, and then I'm going to have to jump into submissions. I'm conscious of the time.
Yep.
I'm going to have to do my best.
Yes.
The first is the chronology that the court has been presented in respect to this site, which one finds in the claim bundle. The chronology starts at page 48 of the claim bundle.
This is tab.
Tab 3.
Yes, thank you.
It's simply that the chronology starts by suggesting that the start of the court's consideration of this matter is that the sale of the land on the 4th of October 2017. Of course, prior to then, there was the grant of planning permission in 2012, and then subsequent to that was the grant of planning permission on the 23rd of March 2016. Now, my lords, my learned friend made a submission today in court, which is that that permission has expired. There's no evidence at all from the claimant. The only evidence the court has to assist the court on that is from the defendant, which is that that permission remains extant.
So what? How does that help us on this appeal?
Well, it's relevant to the question of relief. It's also relevant to the question as to what was before the local planning authority at the point of determination. But it's relevant that irrespective of the outcome of this challenge, there will be a site which has extant planning permission for housing development that will remain sold.
Well, it may or may not. There's an issue about it between you which we can't resolve.
In respect to whether the permission is extant?
Correct.
Well, I say there shouldn't be an issue because the only evidence the court has, there are 4 references in the bundle which say that the permission is extant. There's nothing in evidence to suggest the otherwise.
So your submission is that on this application and this appeal, there is no issue on that.
Well, the only evidence.
Yes, well, we have your reason for that. The evidence all goes one way. You say.
And I can give the court those references if that assists. I'm not proposing to take the court through them all, but I can give the court the quick references.
Well, I mean, yes, all right. Well, no, we'll take it from you for the moment that that's the case.
And I say that because the claimant's opening point was that the claimant's ambition is to restore the land as a recreation ground. Irrespective, as I say, of the outcome of this claim, there will still be an extant planning permission. And indeed, that extant planning permission was relevant to the consideration as to whether the local planning authority were to grant planning permission on this occasion. I also note that my learned friend prayed in aid of the point that there is an ongoing investigation by Shrewsbury Council as to the reasons as to why the land was sold without complying with section 123. And my learned friend says, well, the outcome of that could be that the town council seek to purchase the land back or anything of that variety. I simply say there's no evidence to suggest that the town council are contemplating that. There is simply an investigation. And ultimately, I'm keen that the word council has been thrown around today, but of course, the council I represent, Shropshire Council, had no part in the sale of the land.
Right.
And it wasn't a fault on their behalf, nor is it a duty that applies to the defending council. So in as much as my learned friend says it's a materiality point, the materiality would be that another council made an error. And that... and it's simply that section 123, no part of my case suggests that section 123 was complied with. Indeed, it's accepted that section 123, the town council accepted that they didn't comply with it. The court will be aware, of course, that there was advertisement of this site for 6 months. And I say that's only relevant to the question of proportionality. That the actual requirement that we are considering in section 123 is simply to put something in a newspaper for 2 weeks. And that was the failure of consultation which has led to the consequences, my learned friend says. But there was actually, and my lords, if I can just briefly invite the court to turn up the supplementary bundle. And it's behind tab 5. I'm going to page 52, please. my lord, I'm going to go through this at pace unless the court say otherwise. But page 52, we see a number of dates being provided there as to when various issues were, various marketing stages, the site being on the open market, erection boards. Page 53, we see some of those examples of the actual advertisements that went round. Page 54, again, it's highlighted in yellow. Page 55 in the bottom corner. And page 56, we see the claimants themselves standing in front of one of the boards on the side. I simply just, it's simply just the point that this site was advertised for 6 months. It's the discrete 2 weeks in the newspaper. That is the one failure of Shrewsbury Town's Council, which is, it is said, has led to the consequences that there's now, as my learned friend says, subsisting rights that become a material consideration against the grant of planning permission.
Yes.
I should also invite the court to actually look at the officer report, because the planning permission, the previous planning permission from March 2016, it's just worth noting that that was a factor in the grant of planning permission, and that's behind tab 44 in the supplementary bundle. And within that, we see at page 290, it's page 290, it's paragraph 6.1.12. You'll see at the top of the page that the council had regard to the statutory definition of open space within the Town and Country Planning Act. Then at 6.1.12, they noted the development, second sentence, would not result in the loss of public open space and the provision of 15 smaller family homes rather than the previously approved 8 large eco-homes, i.e. the 2016 permission, will make efficient use of this vacant site and help boost housing supply in a sustainable location. The proposal is therefore considered acceptable in principle. The request to revoke the previous planning permission has been refused. And that's just to note that there was an attempt by the claimant at that point to try and revoke that 2016 permission.
Of course, this is all contingent on the mistaken belief by the council that it's not part of the recreation ground.
Correct.
Yeah. But that was a mistake.
Well,
the question is whether or not they would take the same view if they realised that it was part of the recreation ground, in which case different considerations would come into play.
Well, I say ultimately, the consequences of the sale of land, that's the issue. What subsists, what if anything, after the sale of land was relevant to the materiality in terms of granting planning permission. That's ultimately the main point.
But you see, the whole of this passage in the planning officer's report is infected by the mistake.
Well,
because it's being looked at through a mistaken prism, for which your clients, of course, are not responsible, that it wasn't part of the site, wasn't part of the recreation ground.
Well, that is only a mistake if my learned friend is correct in respect to section 10, section 123 and section 128. Because, of course, if he's wrong, because the sale of land had occurred prior to the grant of planning permission here. So if the sale of land did effectively extinguish it as constituting open space because the rights don't persist, then it wasn't a mistake. It wasn't public open space. I'm going to begin by dealing with ground 2, which is a relatively discrete point, and then we'll have to get into the statute. The first point to note about this sliver of land is that it was the planning officer who was the one who noticed that this sliver of land was not within the ownership of the landowner, that it fell within, it hadn't been transferred. So to the extent that it suggested that this wasn't considered, it was, and indeed it was the planning officer who was the one who spotted it. And we see that in her witness statement, which is supplementary bundle. I won't take the court to it, I'll give the court the reference there. It's the supplementary bundle, tab 5, page 41, paragraph 4.
Without going to it, can you tell us whether the officer proceeded on the basis that the sliver of land was land subject to Section 10 trust?
No, it wasn't addressed.
Right.
The only evidence before this court as to what will happen to that sliver of land, because my lady asked the question about, well, it's the access, and suggesting, well, there was some significance to that. This access will not be developed. There will be no development on this sliver of land, and that is the only evidence that this court has. I'll give the court various references, including the finding of the court below on this point. That was a point that was taken in the summary grounds of challenge, summary grounds of resistance by the defending counsel. The reference for that is claim bundle, tab 21, page 267, paragraph 5.2, Roman numeral 1.
Do you mean that the sliver of land was going to be used to access the site for the development, but once the development was complete, it would revert?
It was the access to the site, but it wasn't. There was going to be no development on this sliver of land.
What do you mean by development?
Any actual works on the actual. Bearing in mind that
not even the final access road to the site.
Correct. That's the evidence for this court is it's an existing access, and I'll.
So how would anybody get onto the site then? Because if you look at the plan, you go down Falstaff Road and then you hit a brick wall effectively. You'd have to go over the land to get into the site.
My lady, the point is that this was an existing access already prior to the grant of planning permission.
Yes, I see.
I'll
From the days when it was
easement,
used as a nursery for trees, for example.
Yes, I'm in difficulty because I've got very little time.
No, all right. Well, I think we have that
take
point.
the
You say
course.
it is an existing access,
Yes, and
and there will be no further work is proposed on it.
And I should say that's a point which was
Anyway, it's an existing access.
yes. Well, my lords, I'm going to take the court. And I'm conscious of the time.
Yeah, no, you just carry. You are limited, but you carry. Don't worry about the time. Just
I'm grateful. So that was made in the summary grounds of resistance. That was supported in evidence, and again, it's the only evidence this court has on it by the witness statement produced by the planning officer, which the court will find at the supplementary bundle, tab 5, page 41, and it's paragraph 2. And what the officer does just there, and again, it's just to curtail my submission, she says, I agree with the contents of the summary grounds of resistance, and it's the summary grounds of resistance that make the point there's no development. And indeed, the court below made this finding, that there will be no development on the sliver of land.
right.
So I say, my lord, in terms of the court's role today, this is a finding of fact of the court below, and that was found at paragraph 119 of Mrs. Justice Lang's judgment, which is page 136. And she says unequivocally.
Well, it's in the judgment. We don't really need to turn.
No,
it
don't worry. Yeah.
Yeah, there is no proposal to develop it. And that's relevant because the national policy in respect to open space, if I can invite the court to turn it up, it's at tab 48 of the authorities bundle. My lord, this is the crux of the local planning authority's decision. Paragraph 97 of the MPPF. This is the national policy that deals with deals with open space. You'll see the opening text of the policy, existing open space. Not historically open space, not it once was, not those subsisting rights, existing open space. And then it goes on to say, should not be built on unless. And that's obviously relevant to this sliver because it won't be built on. There are two quick references I need to give the court on this ground 2 point, which should put this beyond doubt, I say. They are to show the court what that right of access was, and that's in the supplementary bundle behind tab 38. Do stop me if I'm going too fast. Supplementary bundle, tab 38, and it's page 212, please.
Now, we haven't got page... Sorry, what are we looking at?
It's the supplementary bundle, my lord.
Oh, forgive me. It's in time. Sorry, I haven't got the wrong bundle.
Those who have it, it's the bottom of the page and schedule. 1212.
Paragraph 1, the right of way.
Page, sorry again, give me the page.
Thank you. Sorry, my lord, it's 212.
212. And,
Right at the bottom.
yeah, thank you.
So in the transfer of land, that a right of way at all times for usual and reasonable purposes connected with the enjoyment of the property of the access.
Yeah.
So that access and final reference, which is that the officer report does consider what impact there's going to be on this access and says there won't be any. So that's in the actual officer report itself, which is within the bundle that you're currently looking at. It's behind tab 44, and it's page 303. It's paragraph 7.3 on 303.
It's 7.2 or 7.3 or both.
It's both, but the key point is 7.3, which is that the vehicle access, it won't have the impact. The additional vehicle movements won't be significant. So just drawing those threads together on ground 2, it was the officer who had regard for it, so they can't be criticised for not having regard for it. There won't be any development on it, as the court found below, and the only evidence this court has on that subject. There is an existing right of access already, so there's no interference and there's no augmentation of that, because the officers say, well, there's not going to be any impact. And in any event, it wouldn't engage national policy, because it's not going to be built upon. I'm going to move on to deal with some of the authorities, if the court are content. The reason we are here today is because Mrs. Justice Lang recognised that there's no authority on this point. That's her express reason as to why we're here. So my learned friend goes through a number of the authorities, but the point is this express point that this court is being asked to consider is not actually dealt with in the authorities. So whilst I can go around and try and glean various points from the authorities, I say none of them are on point. It's this court having to deal with the interrelationship between Section 10 of the Open Space Act and Section 123 and 128. I can respond to the various submissions my learned friend said on the authorities. Conscious of the time, the quick point is none of these authorities directly deal with it. And indeed, Mrs. Justice Lang, that's what she said. She also recorded that as a point of agreement in her judgment at paragraph 109 on page 134 of the claim bundle. My lords, there's a point about material considerations, because ultimately my learned friend's case is boiling down to the position that, well, if 128 has the effect which he says the learned judge, the court below found, which is there's a subsisting right, my learned friend says, well, that's a material consideration that needs to be factored into the grant of planning permission. In terms of material considerations, my lords, there's a helpful summary of the position on material considerations in the context of planning as it's evolved recently of late from the Supreme Court judgment, and that's provided by Mrs. Justice Holgate in the Client Earth judgment. And I'm going to very briefly turn that point up, my lords, which one will find in the authorities bundle behind tab 46. I am conscious I'm going fast. If I'm going too fast, do...
That's fine, we will, but it's fine at the moment.
My lord, so it's tab 46 in the authorities bundle, and it's page 21 of the judgment. Paragraph 99 and 100, Mr. Justice Holgate helpfully summarises some of the recent authority, including the Supreme Court judgment of this year and Samuel Smith. And the critical point, which is that it is insufficient for a claimant simply to say that the decision maker did not take into account a legally relevant consideration. A legally relevant consideration is only something that is not irrelevant or material, and therefore something which the decision maker is empowered or entitled to take into account. But a decision maker does not fail to take a relevant consideration into account unless he was under an obligation to do so. Accordingly, for this type of allegation, it is necessary for a claimant to show that the decision maker was expressly or impliedly required by the legislation or a policy which had to be applied to take the particular consideration into account, or whether on the facts of the case the matter was so obviously material that it was irrational not to have taken it into account. In the Samuel Smith judgment, it makes the point the obviously material is obviously material by reference to the statute. So for my learned friend to get home on this materiality point, even if he's right about it subsisting, he has to establish what in statute or policy meant that the local planning authority had to. Not that they could, that they had to. And therefore, it's a legal error that warrants the decision being quashed. And my learned friend, I've made this point in my skeleton argument. My learned friend hasn't pointed to anything now. Obviously, he's got the right to reply, but I don't know what he's going to refer to in legislation. That would mean that one is required to have regard for the fact that a parcel of land was sold incorrectly by a different local authority historically. He may say it's Section 10 of the Open Spaces Act, but of course Section 10 is a requirement that would be imposed on Shrewsbury Council, not on Shropshire Council. So that's not a legislation. That's not legislation that would have effect on Shropshire Council as the local planning authority making a determination on this planning application. This is all to say that even if my learned friend's right about Section 128 and 123 about it subsisting and that being the point is my learned friend says that's a material consideration that needs to be weighed into the planning balance, which could have tipped the scales against the grant of planning permission. And I said, well, where is it that required the local planning authority that had to have regard for that point? I ask rhetorically because my learned friend doesn't point to anything. I hope I don't find the answer in his right of reply. My Lords, a point was raised about the area of land being administered pursuant to the Section 10 of the Open Spaces Act. I'm not sure whether the courts will have got this point, but this area of land is not subject to any administration or maintenance by Shrewsbury Council. Indeed, there's evidence in the bundles on that, if I can, the court would be assisted by reference.
I see.
Just
You mean they just leave it alone?
Well, they have no control.
Well, they don't now. No, of course. No, I follow it. I mean,
Yeah.
since it's sale.
Correct.
Yes.
And it's simply because there are circumstances where a local authority might sell land, it being private ownership, but they still have an obligation under a trust to maintain it, and because they have a right of access. Here, they don't.
Yes, I see.
My Lords and my Lady, there's a procedural point which we raise in our skeleton argument, which is that the claim that's now been formulated before this court is not the same claim that was formulated before the court below. Because my learned friend makes the point about Section 128 of the Local Government Act. That was the point that was dealt with by Mrs. Justice Lang. The new point that my learned friend raises before this court is to say, well, if it does subsist in any fashion, that is a material consideration.
If the trust subsists in any fashion.
Because my learned friend's point in the court below was that the consequences, Section 128, the failure of Section 123 was that it remained open space. His point now is, well, that's his primary position, but his secondary position, which he pursues pursuant to grounds 1 and 3, which is that, well, if it wasn't that, and it was just something that subsisted, then that was a material consideration which needed to be factored in to the local planning authority's determination of this application, and their failure to do so warrants the decision being quashed. So it's a failure to have regard to material consideration point. That was never pleaded before Mrs. Justice Lang. You'll note she doesn't deal with it, and I can take the court to the claimant's pleadings in the court below. I do set out this procedural point in my skeleton argument from pages 2 through to 6.
So when you say that the point below was that the land remained open space, what you mean? What did that mean? Did it mean that the new owner was obliged to keep it? I won't say maintain, but keep it as open space available for the public. I'm not quite sure what that means.
Well, perhaps if I take the court to what the claimant's position was, because my lords, they won't find anything in Mrs. Justice Lang's judgment about whether this was a material consideration. And the reason was because that wasn't the issue that the court was dealing with below. And significantly, it's not a point that the defendant counsel has produced any evidence.
I see. Yes, I see. So his point, would you better just show us briefly, if you can,
yes,
what you say their position was?
The grounds, my lord, one will find in the claim bundle behind tab 22. Claim bundle. And it's page 290. Provides a useful
So parrot page, what is it again?
my learned friend tells me that the grounds are 288. I was taking the court to 290, which is the issues. Well,
It's clearly pleaded on 289 at letter C that disposal of the site did not free the land from the statutory trust.
Yes, my lord. Yes, my lady. But it is not said. Well, I mean, the legal construction of the effect now of Section 123 and Section 128. My learned friend's alternative position is that now this is a subsisting but not enforceable right, but one that still is a material consideration that needs to be factored into the grant of planning permission. And the point is, it's a material consideration argument, which was not advanced before the court below. The court below were trying to engage with the consequences of Section 123.
Well, issue 3B directly asks whether, if the land is held under a statutory trust following its acquisition, whether the grant of planning permission is unlawful in light of the county council's failure to have regard to that status. Isn't that wide enough to cover a materiality challenge?
Well, that status, but the status now being a subsisting but not enforceable right.
I think we're splitting hairs a bit with respect.
Well, I say in terms of it being a material consideration, the defendant counsel don't have evidence before this court, nor did it have evidence before the court below as to, well, here are the material considerations that were had regard for, and here are the reasons why the impact this would have as a material consideration.
We've got the planning officer's report, which was adopted. So what's in the planning officer's report will contain all the material consideration.
Very well. I should say that the point that my learned friend raised on his feet today, which I'm not sure whether is still pursued, which is that notwithstanding the subsisting rights, that is a factor which would inform a I'm not wishing to mischaracterise my learned friend's position, but it was an amenity argument about whether this site could constitute open space. I didn't understand that point while my learned friend made it, because that would seem to suggest almost setting aside the background to this having been once open space, that there is a freestanding point that this could have been open space as in terms of its amenity value.
Well, I think that's why my lord explored it with him, and I think eventually there was a certain amount of retreat from that.
I think we're firmly anchored in the status of this land as having been subject to Section 10 of the Open Spaces Act.
I'm grateful. The only point that I'd add is that the officer report actually found that this site didn't have amenity value, and actually that the proposed development would allow for an amenity value to the site.
Right.
My lords, they're all sort of preliminary background points. I'm going to jump in, therefore, at dealing with the nub of the issue, which is, now I've dealt with the sliver of land which isn't affected by Section 123 and Section 128. I'm going to deal with Section 128 and what I say the consequences of Section 128 are in this circumstance. I'll be following my submissions and my skeleton argument, but from page 10. Starting with 128, I say that the plain meaning of what this is, it's got to do something. 128 2b. I say that what it does is when a purchaser, such as CES Developments, the interested party here, have purchased a site where it said that they don't need to be concerned to see or inquire whether any consent has been given, it effectively means that the failure to comply with Section 123 is effectively immaterial.
What's the point of having Section 123 at all?
Well, I'll turn to 123 to answer that point. 123, the court obviously finds behind tab 6 of the authorities bundle. 123 is to provide a consultation. That's the function of 123.
It's to give the potential objectors an opportunity to stop the sale, isn't it? Surely.
Well, exactly. And ultimately, what should have happened here from the claimant's perspective is they should have challenged the sale of land to Shrewsbury Council.
Well, if they knew about it, they might have done. But I've got your point about it all being advertised for 6 months. But leaving that to one side, if we're looking at the purpose of construction of this statute, Parliament's intent is obviously to give somebody an opportunity to object. That's why they're going to be notified. So if that purpose is frustrated by the council, for whatever reason, failing to do that, you can't wind the clock back. But why should... I just wonder, why should the council be allowed, if you like, to frustrate that purpose by simply selling it off to a developer and then saying, well, we wash our hands of it, it's just too bad, you can't object about it, and it doesn't even feed into questions of planning permission anymore?
Marlene, that question conflates two councils.
Yes, I know.
So I can't properly answer that because...
Well, you've got. I know you've got your point about the fact that in this particular instance, the council which is selling off the land is not also the local planning authority, which is an extra wrinkle. But if you're right, and it just destroys the statutory trust, what on earth is the purpose of having it there?
My lady, the role of local government, within statute, it's littered with statutory requirements to consult, screening opinions, habitat regulations. We don't need to look far to find occasions where you need to include members of the public. As far as this goes, this is perhaps one of the least onerous I can think of, putting something up for 2 weeks in a newspaper. And where that is breached and there's been a failure to comply with it, there is a statutory requirement to do it, and therefore it is an unlawful decision to sell in spite of that. Yeah. So that any individual finding himself in the claimant's position can bring a legal challenge. He says he doesn't know about it, but obviously I don't know about that. I don't have evidence on that. But ultimately, the court has discretion to extend time. There are remedies, and that's what this protects. It protects the interaction with members of the public to being notified about it.
But Section 128 takes that away by giving inalienable rights to the person who's actually bought it.
Well, actually, 128 doesn't serve to frustrate 12328. So if someone were to challenge the sale, one can't use Section 128 to say, well, no, it's done. So the day after the sale, 128 effectively overrides it. 123 would effectively provide still that legal challenge, provided one brings it within the times of the civil procedure rules. But after that period expires, where the sale is gone, and it's in principle, it's an administrative decision, so it's assumed to be lawful. One thereafter, the developer or the benefactor of the purchase need not concern themselves with. So they cannot be at any detriment for any failure that might have come, which they, of course, would have had no involvement with. And where it said they cannot be required to see or inquire, well, it must mean that any impediments that would flow from a failure cannot be held against them.
Is your submission that Section 128 is subject to the potential of a challenge, so that there's a time limit that kicks in?
Well, effectively, yes, particularly because...
I don't understand where that comes from.
Well, in Section 128, that's in the situation where a person is dealing with the authority. Well, clearly here, CSE developments were dealing with a local planning authority in applying for planning permission.
I'm sure it's entirely my fault, but I don't understand why Section 1282A doesn't apply immediately, that you've got an exchange of contracts.
Well,
I think that was the issue that Mr. Justice Elias
Yeah.
had to deal with, and he held that it didn't apply at that point because he construed dispose as meaning completion of the sale rather than the exchange of contracts. But I mean, I don't understand anyone to be challenging or saying that Mr. Justice Elias was wrong in this case. Anyway, we'd better let you develop your submissions, I think, Mr. Garvey.
I'm grateful. I should say I welcome the interventions because it's the only way I'm going to get to the nub of the issues in the court's mind. But
looking at the starting point, which is 123(2)(a), which means that the council can't dispose of land without complying with these requirements. So if it does, it acts unlawfully, full stop. We then go on to relief, which is a different kettle of fish, and that's what COCA and all those cases are about. But 2B concerns me in the context of your submissions, whereby we've looked at this, and I think it's common ground that this means that if the requirements are not complied with, if the requirements are complied with, then the land is freed from the trust. If the requirements are not complied with, what? I mean, the reverse in 2B is compliance, no trust. Non-compliance, trust remains. Or is that not right?
well, these statutory provisions are obviously there's difficulty reconciling them.
Yes, there is.
But I say that the only correct way to reconcile them is that to the extent in which it's said that any trust would persist, it is not a trust that could be held against the purchaser.
I've got that. That's a different point. It's a later point. At the moment we're on, does the trust subsist? We'll work out what the consequences of the trust subsisting are, as Mr. Justice Lang did. But does the trust subsist, or does the trust go?
I say, my lord, that the reality of this trust, which one actually needs to look at when one looks at Section 10, is the reality of the trust is it must go. Because how could that trust under Section 10 exist divorced from Shrewsbury Council?
Well, again, we've got to break that down into two parts, I think. Firstly, as my lord said, looking just at Section 10, there is, in my view, huge force in that argument, that Section 10 looks as though ownership, obligations go hand in hand. So the question is, or I think could be put in terms of whether this provision or any other provision effectively changes that position. And as my understanding is that it's said that these provisions do. These provisions give a different result, whereby the ownership and the obligations can be split.
Well, my lord, I have a real difficulty with that point. One, because Section 10 doesn't say that, but also the ownership obviously isn't by a council. So in that respect, Section 10 doesn't work. But if it is that the obligations still exist, I'm struggling to see who that obligation exists against.
Who owes the obligation?
Indeed. And
You mean who is obliged?
indeed, because Section 10 would suggest that the obligation should carry across, but of course the Section 10 obligation couldn't carry across to CES developments, and they couldn't be required to administer this land for the benefit of...
It can only stay with the council.
Indeed. But, and I suppose, even if I'm wrong on that, coming back to the question that ultimately we are not looking at, we're looking at the context where Shropshire Council are being asked to determine a planning application. To what extent is an obligation that exists on another authority, an obligation which they have to engage with as in terms of a material consideration, bearing in mind that for it to be a material consideration that can justify the quashing of planning permission, it needs to be a material consideration that is linked with a statute, being obviously material to their determination. Oh, I suppose there's an academic question, which this court isn't engaged with in that scenario of, well, what happens if Shropshire Council had sold the land, and therefore, on my learned friend's construction, Section 10 would still exist on them. But we don't find ourselves in that situation, because to the extent that that obligation, if it does persist, which I say it doesn't, if it does persist, it's not an obligation that arises for the purposes of Shropshire Council, because they never owned the land, and it was never an obligation that they had to meet. But I say, my lord, that distorts.
If that's right, you'll focus on Section 10, which I think is a strong point for you in the linking of ownership and obligations. But in Section 123, Section 123, 2b, this says, where by virtue of subsection 2a, that's where the requirements have been satisfied, the trust goes. Well, what's that subsection doing there if the trust goes whether the requirements have been complied with or not? So dispose of the land, the requirements you say under Section 10 automatically go. So what's that subsection doing?
Well, my lords, I mean that's a tricky question.
I know.
It is. I mean, it's a tricky question too, because if one looks at the wording of Section 2, subsection 2b, it refers to, after the opening part, the land shall by virtue of the disposal be freed from any trust arising solely by virtue of its being land held in trust for enjoyment by the public. Now, once the land is sold to the purchaser, I think it seems to be common ground, it's not land held in trust for enjoyment by the public. And I find it difficult to see how this trust survives. I don't understand the content of the trust, the nature of the obligations that survive with Shrewsbury Town Council, having disposed of the land. This language seems to tie in with the point that we'll be making about Section 10.
I suppose that the other point to that is Section 123(2)b does not say the exclusive way in which a trust can be extinguished.
Well, yes, but there is nonetheless the curiosity, isn't it, that it goes out of its way to say it is extinguished in this particular way.
I mean, the sort of broad point that you put is that Section 10, you say, is clear, and that is ownership and obligations go together. And 123(2)b is not a straightforward provision, but you say it cannot, in all of the circumstances, disrupt this linking of ownership and obligations in Section 10, because if it was going to do that, it would be clearer.
Correct. And there's another point. It cannot disrupt the effect of what Section 128 does. Which is to give that protection to the purchaser. Because on my learned friend's construction of what Section 123 can do in terms of it undermining the effect of Section 128, I say Section 128 should provide that protection. I'll make a few points on that. But on my learned friend's construction, Section 123 would have the effect of robbing Section 128 of that protection that would be afforded to a landowner. My lords, anecdotally, I'm in the process of purchasing a house. If my conveyancing solicitor told me, you don't need to be worried about that, you don't need to see or inquire about that, I would be satisfied. It's not something I'd ever need to be concerned about. If I was told later down the line, actually, you've got the title, but you can't do anything with the site. Or you've got the title, it's not open space for the purpose of paragraph 97, but it's a material consideration that can weigh against you and could result in you not being able to do anything with your site. Well, naturally, I would wish to see or inquire about that. And that's what section 128 does. It protects purchasers from not having any failure in respect to section 123 from being held against them.
That depends on whether it's given a wide construction or whether it's given a narrow construction.
Correct.
If you're right about the wide construction, I can see the point.
Well, I was going to ask you much the same thing, but just to be clear, have you really said what you want to say about section 123 before we move the focus to 128?
Yes, my lord. Although I mean, all the.
I mean, I know they interrelate, but is it a good moment to proceed to 128?
Yes.
Yes, fine, good. Well, then, my lady, I think, has raised the nub point here, isn't it? How do we construe 128 to A and also B? So, obviously, we want to hear you on that.
Yes, my lord. And I say the first point is looking at section 128. It's 2B must do something different to 2A, and I think it would be wrong to suggest that 2B only attaches to appropriate or acquire. That's just not the natural reading of the language. So if 2B does something different to 2A, well, 2A protects the validity of the title. 2B must do something more. Now, if it is said, in using this scenario as the example, that actually, if I'm someone from CES Developments, and I'm being told actually, there's a statute that says you don't need to see or inquire, but actually, your site's actually open space. Or, alternatively, it's a material consideration that once was open space and there are now subsisting rights, and that is a material consideration contrary to you being able to develop your site. I would say, well, that's something I would wish to see or inquire. And not only would I wish to see or inquire, I might scratch my head and think, well, I wouldn't have bought the site, but there's nothing I can do about that. Because section 2A means that the validity of the title, now I know that, now I know there's been an error in the sale of the land, I can't do anything about it, because it keeps the title with me. I might not want it. In that respect, actually, 2B on that narrow construction, it works to my detriment.
Well, it does, and that begs the whole question of what 2B is there for, because in one view it could be simply belt and braces, protection against getting bad title, because the effect of the previous statute is that any disposal which is made without getting the requisite consents or doing the requisite publication is ex hypothesi an unlawful disposal of the land. And whilst A might be enough in and of itself to protect the innocent purchaser, some bright person might otherwise have argued, well, it protects the innocent purchaser, but it's subject to an implicit assumption that the purchaser is a bona fide purchaser for notice for value without notice, and there may be constructive notice issues because they were put on notice of X, Y, and Z, and subparagraph B could squash that potential line of argument. In other words, they're two sides of the same coin. One of it's looking at it from the point of view of the council's actions and saying they are deemed to be valid to give good title to the purchaser. And on the other hand, 2B is saying the purchaser is not to be deprived of that good title by virtue of having not made appropriate inquiries. So although it may well be adding very little, it's adding something.
Well, Lydia, I really struggle with that, because that would suggest that 2A is directed towards local planning authorities and 2B is directing itself to the person.
No, 2A is directed towards the conveyor of the land, the owner of the land, which may or may not be the local planning authority. So it's the person who has broken the statutory requirement to get the consent or whatever it may be. And it's making it clear that the failure to do that does not deprive the purchaser of good title. So nobody can turn round and say, because the council broke its duties under the earlier statute, because it was open space and it didn't jump through the requisite hoops, you don't have good title. So it can't run that argument. That's what 2A does.
Well, that's a helpful point about why I said 128 comes in after the JR period for
Correct.
123.
Well,
Because
yes.
if anyone did challenge unlawful disposal, it could
Yes.
never be said, well, the title's valid now, so he can't do anything about it. The court would have the power to quash the sale of the land and revert it back to, which means that 128 must have the effect I said, which is it must be engaged effectively after the point at which anyone has had the opportunity to challenge it.
Well, that's a fair argument. But I don't think there's really any issue as to what 128A actually does. It's really, it's B that we're concerned with. And the point I was making was that it protects the purchaser from an alternative argument, which is not so much a thrust of the failure of the conveyor to cover their statutory duty, but a failure on the part of the purchaser to find out about it. There are two potential ways in which you could attack the sale. One is to say there's a breach of statutory duty in making this sale in the first place. The other is to say, well, the purchaser was on notice of that breach of statutory duty and therefore should be deprived of that protection.
My lady, but the developer, there's no duty on them, and ultimately, if they buy a bad land, normally without this, that's on their head, be it. This is to say, well, you cannot buy, as an independent party from a local planning authority, you cannot buy land which is hindered by any failure on behalf of the way the local planning authority might have sold it to you, subject to the point that the local, unless someone challenges it through Section 1.2, a failure on Section 123. That must be the way it works, because otherwise, the day after someone makes a sale, you could just say, well, you can't challenge the validity of the sale. So there must be a window in which Section 123 bites prior to Section 128 being engaged.
Sorry, so let me try and understand this. If the town council here has sold this land to
CS.
yes, and completed the sale, that's it, isn't it? Under 128(2)(a.
No, because it would have been open to the claimant to bring a challenge to that sale, highlighting the failure of 123(2)(a, and the authorities point to the fact that that would have been a lawful challenge.
At what point? At what point, though?
Within the judicial review period.
You mean after completion?
Correct.
I'm not sure.
I don't. How? Where'd you get that from?
Well, my lord, there's a judgment Whitstable. My lord, it's paragraph 4.13.
Where is it?
Where is it?
The actual authority, my lord. I put them up page 12 of my skeleton, but I'll give the court the actual reference to the actual. The first is Bolsover, which is hand tab 25. The authorities bundle.
So do you want us to go to Bolsover?
Well, my lord, this is just responding to the court.
Well, I mean, I don't want it to go down, but I'm slightly surprised to hear you. Whitstable is at 40, if you wanted that. I mean, if disposal means, as Mr. Justice Elias construed it, I think, completion of the sale, transfer of the legal title, then I don't understand why 128(2)(a) doesn't immediately bite. Because, I mean, otherwise, and I thought this was in a sense the point you were making, the person who now holds the legal title, the purchaser, is in a period of risk for a period of months, which itself could be extended. Whereas it would look to me as if 1282 was designed to provide finality in favour of the purchaser.
Well, my lord, that being the case, I still circle back to the point, which is that if 1282b
Yeah.
only gives that limited protection, it's a protection
Which limited protection?
that the site could still be qualified as open space, i.e. they can't really do anything with the site.
I see. Yes.
Then it's no protection at all.
I see that. Can I just raise this in respect of 1282A and B? And it goes back to the persons on whom protection is conferred. And they do seem to be different as drafted. Because A is in favour of any person claiming under the authority, which we certainly includes somebody, certainly includes a successor in title. Whereas B is a person dealing with, and then insert little 1, the authority, or little 2, a person claiming under the authority. So that does suggest that B is actually looking at a different category of person from A.
My lord, I confess I didn't read it in that way until the court said that there. I'm not sure how much turns on it. I read that.
No,
as
I'm not sure either. But
a person dealing with the authority, or a person claiming the authority, which would mean 2B talks about the same person as 2A. They're both a person claiming under the authority, but 2B deals with an additional suite
could be.
person.
It could be. Yes. It could be.
That was.
I mean, it's certainly capable. I mean, someone who buys the freehold with vacant possession, as I imagined happened here, is, I mean, as a matter of ordinary language, is certainly a person dealing with the authority.
Correct, my lord.
Yeah. All right. Okay.
My lord, I mean, someone applying for planning permission from a local planning authority could equally be regarded as someone dealing with the authority. Because if they're dealing with the administrative
Well, I
functions of
think
the
that
local planning
becomes a
authority.
little bit more. I wonder if that's so. But that's an added complication which is not necessary for our purposes, I think.
I suppose the only point is there's no reason why 1282B should not apply in the circumstance we find ourselves, where CES development are trying to seek planning permission.
No, I see.
But it's the person dealing with the authority. That's the authority disposing of the land. That's the town council, not Shropshire.
Yeah, so a person claiming under the authority being a person claiming under the authority that's been sold.
I mean, you would only have a point in a case where the authority disposing of the land was the planning authority.
As you rightly say, I think that's a complication we can leave for another day.
I'm sure that's right.
Yes.
My lords, if there was still only this limited, the narrow interpretation of Section 128 favoured by the appellant, it would mean that would obviously have implications for the purchase of land of any local authority, because no developer is going to be able to satisfy themselves fully that the land was or was not open space or otherwise. I mean, in this circumstance, this is the result of the claimant having gone through the archives of Shrewsbury and Shropshire to uncover these documents.
Yeah.
No landowner is going to go to that difficulty.
But we still, I mean, what we still have to tease out is what is the effect, even if the trust, whatever it is, does subsist, what effect that has on the A, on the authority, and B, on the purchaser. I mean, it's not contested, not suggested, as I understand it, that the obligation is owed by the purchaser or is binding on the purchaser. I don't understand that to be said. What it so the purchaser is free in a general sense, but so the question is what is the authority, in this case the town council, required to do in order to perform its duty, its obligation. And then, critically, your point, what is is that a material factor for the planning committee to have regard to in this case?
Yes, my lord. There's a few points to unpick there.
Yep.
The first is let's assume for one moment, and I say that the effect of section 128 2b, and I say section 10, but that trust cannot be carried across. They can't be divorced. I also say the effect of section 128 2b is that any such trust, if it did subsist, is effectively no trust at all, because it can never be enforced against subsequent purchaser. Effectively, it's of no effect. The ultimate question is, to what extent, if at all, does a local planning authority have to, in this circumstance where they have not made any error, do they have to have regard for this in discharging their statutory duty? It certainly doesn't engage anything in terms of the application of policy. Even if there is subsisting rights, that does not make it open space. It would simply mean that there's a subsisting trust, but it is not existing open space. Because section 10 no longer applies to it. Ultimately, if there's no right of the public that can be enforced, in reality, what right actually is that? I'm struggling to understand the concept of a right that you can't actually enforce to begin with. And what in legislation would make that a material consideration that must be borne in mind, having regard for what's said in the Client Earth and the Samuel Smith? My lords, let me make a few final points on section 128, if you will.
Certainly.
Section 128 is obviously entitled Protection of Purchasers. So I say that the natural reading of this must be consistent with that. This must provide that protection. And the narrow interpretation favoured by the appellant, as I say, is not protection. It's a detriment. Because it leaves them with land which potentially they can't use, or they can't develop in the way they want. It's also worth pointing out the requirements of section 123. As I said to my lady earlier, the section 123 requirement of simply putting something in the newspaper for 2 weeks, it's a very easy requirement to comply with. I know it wasn't complied with in this instance, but in terms of the proportionality of the consequence of that, a failure to consult for 2 weeks, potentially drastic impacts upon the subsequent purchaser. And significantly, it's unclear how this trust, if it does subsist, and if it is material, how one could ever extinguish it.
On the basis you can't put the genie back into the bottle, you can't unscramble the sale contract and then give the notice and then go through the right hoops.
Correct. That deals with my point about section 128 and why I say ultimately my primary point is it's not a trust that does subsist, because section 10, it can't be divorced, and that will be contrary to section 128 2b. If it is a trust that subsists to some extent, it can't subsist to the detriment and be relied upon as a detriment to the purchaser, because that would be contrary to 128 2b. So in this circumstance, if it is a trust that subsists, it wasn't material to the local planning authority's determination of this application. And also the point of relief, that this is a circumstance where a local planning authority had already granted planning permission in respect to this site. And here they were faced with another planning permission, which they said was better. I should also say, dealing with the actual MPPF, which is the offence that the local planning authority in terms of misinterpreting it and not applying it correctly, I don't understand how the persisting trust, if it does subsist, means that this site qualifies as existing open space for the purposes of the MPPF and paragraph 197 of the MPPF, because ultimately, if the public cannot enforce their right over the land, then how can they ever gain access to the site and enjoy it? How can they enjoy these rights, which apparently subsist? And that means if they can't enjoy it, necessarily follows that it's not existing open space for the purposes of the MPPF.
I think Mr. Goodman relied on the sort of visual impact of the site, even if the public couldn't have access to it. It was there as a piece of adjacent open land, and therefore had. I'm not sure. I don't want to put words in his mouth, and I may have got the point slightly wrong. But that was the nature of the submission.
Well, yes, my lord. In that case, let me take you to the actual officer report, which deals with that point. The officer report is in the supplementary bundle. I've reached that stage in my submissions, my lord, where I've lost track of where my bundles are.
Well, I think it's either 40 or 44. I think the revised one is 44.
You're quite right, my lord. It's 44 of the claim bundle.
This is in the supplemental bundle, isn't it?
That's correct.
Yes.
Correct. My lords, page 293. Oh. 6.2.15. In addition, this is the conclusion section on the layout, scale, design, and appearance and visual impact. In addition to this enhancement to the visual amenity of the recreation ground, the proposal also brings some benefits in terms of improving public safety. The footpath, recreation ground, and play area will be overlooked by the new development, thereby improving surveillance and deter antisocial behaviour. The development of the site will make good use of private land, and its current overgrown and neglected state makes a negative impact on the visual amenity of the locality. So just in terms of that value that site enjoys? Well, that comes down to a pure question of planning judgment, and the planning judgment for local planning authority was actually this development's going to improve the site.
Right.
So to the extent of which there is a subsisting right to enjoy it, well, it's a subsisting right to enjoy which is enhanced through this development. That's just a pure question of planning judgment. And similar, my lords, just while we're looking at the officer report, page 302, if you would please. My lords, 6.8.1, MD2 requires the provision of open space on site calculated at 30 square metres per person based on a standard of 1 person per bedroom. Here we had 15 dwellings. However, due to the large recreation ground adjacent to the site, it is not considered necessary to provide on-site open space in this instance. Again, into the realms of planning judgment, but the local planning authority thought, well, we don't need to have actually any physical enjoyment of open space on site here, because they've got the recreation ground adjacent to it.
Yes, that may be going to a slightly different point, I think. But anyway. Yes.
Well, my lords, I say the subsisting right, to the extent that they're not enforceable, then they're no rights at all, and certainly they're not material considerations. But even if that's wrong, it's clearly not the case that this is the sort of decision where the local planning authority were going to reach a different conclusion, when if there was subsisting rights, and they could only have been in terms of amenity, here was a site where the local planning authority saying, well, this is a development that's going to improve that visual amenity for members of the public. We don't need to have any on-site provision because they've got the recreation ground next to it, and it's better than the scheme, which is extant now and challenge-free.
Right.
My lords, just excuse me if I can check my phone to those who instruct me.
Yes, sir.
See whether there's any points.
Yep.
Yes. It was the one final point, with my lord, which is the definition of open space
Yes.
within the MPPF, which I believe was a document my learned friend passed out
Yes,
this
he
morning.
did. I think we've put it into the, I forget whether it's in the authorities or...
It's in the authorities with the rest of the MPPF, I think.
Yes.
40 something.
This is at tab 48. Yeah. Yes, tab 48.
I'm grateful, my lords. And just in terms of the definition of open space, we find there, for the purpose of, this is obviously to qualify as open space, for the purpose of paragraph 97 of the MPPF, one has to meet this definition. All open space of public value, including not just land, but also areas of water, which offer important opportunities for sport and recreation and can act as a visual amenity. So it has to have the sport and recreation and the visual amenity. Even if you have the visual amenity, which my own friend says this site has, contrary to the planning officer's judgment, well, it doesn't have the sport and recreation, because no member of the public has any enforceable right to gain access to the site.
I mean, given the absence of a comma in the second and third lines, I wondered whether the offering important opportunities simply qualified areas of water.
So he said.
I mean, sorry. I mean, when we were taken to this by Mr. Goodman, it says open spaces all open space of public value, including not just land, but also areas of water which offer important opportunities, etc. Now, while there's a comma after not just land, there's no comma in the rest of it, which suggests maybe that offering important opportunities and so on is simply qualifying areas of water. But that may be to lay too much stress on the presence or absence of a comma. But
I think it may do, given that Anne can act as visual amenity.
Yes,
Or
well,
thought apply both to land.
oh, it
and
could do,
sea.
certainly.
Well, but I would say that to qualify as open space of public value, you've got to have the visual amenity, and you've got to have
Yes.
Yes,
I see what you mean. I understand what you're saying. That it's got yes, I see. So in a sense, they're applying to water the essential elements of open spaces of public value.
Correct.
I follow the point.
Yes.
Yes. Yes.
To qualify
I see.
to qualify as open space, you've got
It's got to be offer important opportunities for sport and recreation and act as a visual medium.
correct. And this site doesn't offer the sport and recreation
Yeah, I follow.
because, and just
Part of you can't enforce.
indeed, and just to underscore that point, the definition of open space in the Town and Country Planning Act, which is slightly different, we find in the officer report, does talk about the public garden, or public recreation, or disused burial ground, and that's found at page 290 of the officer report.
All right.
My lords, that was the final point from those
Well,
instructions.
thank you very much. I'll just ask if there are any further questions. No, well, thank you very much, Mr. Garvey. We're grateful. Yes, Mr. Goodman, you've got about 6 or 7 minutes.
I'm grateful. The first point, the question of whether the previous permission has expired. I'll just give you the reference, tab 14 to the core bundle, page 149, paragraph 14 of my skeleton argument below was where I argued the point that it hadn't been implemented and the conditions hadn't been discharged. So that's where the point
So
is
just
from.
give me the reference again. It's SB...
Core
Supplement-
bundle, tab 14,
Oh, core bundle, tab 14.
page 149,
Yeah. Okay.
paragraph 14 of the skeleton argument below.
Thank you. Yes.
Then my own friend 3 or 4 times referred to the requirement under section 1232A as being simply advertising in a newspaper for 2 weeks. That is not the requirement. The requirement is to conduct a consultation, which involves a much more fundamental obligation on the local authority to conscientiously take account, in accordance with the gunning principles, etc., of the consultation responses, and to make an informed decision on the disposal in the light of public views. It's not simply this stick an advert in and then sell it, as my learned friend repeatedly implied. The submission was made that on the basis of client earth, that I need to make out that there is a material consideration, and I haven't done so. It misunderstands the structure of the argument. Obviously, in terms of the grounds for challenging the planning permission, I have established that there were what the judge called clearly material considerations that were not taken into account, and they are material considerations that were required by legislation to be taken into account under section 38(6). That's the requirement to decide in accordance with the development plan, and under section of the Planning Compulsory Purchase Act 2004, and under section 70 subsection 2 of the Town and Country Planning Act 1990, the obligation to take account of all material considerations. The NPPF and the development plan policies on open space. So in terms of attacking the decision, clearly I have made that out. There's no cross appeal against that. The structure of the argument here was all about the question whether the judge was correct not to quash because of the section 31(2)A considerations, and that's I've given my submissions on that, but it's important to clarify that the way in which that's structured. As to the argument that I've been making a new point, the court's already alluded to the way in which the grounds, as pleaded from the very outset, are essentially still the same. If you want to see the skeleton argument below, it's at page 166 of the core bundle.
That'll be at 14 again, right?
And that's tab 14 once again, and it's paragraph 55. You can see that the point was squarely made that's at issue in this, save as my lady suggested some hair-splitting details may have evolved in response to the way in which the judge decided it, but there's nothing unusual about that. As to the contention that my clients should have challenged the sale, the disposal of the land, I concur with the observations from the court that that would seem to be inconsistent with section 128. And non-compliance with section 123 is precisely what's captured by section 128. So there isn't any opportunity, even if they'd known about the disposal, which they didn't, to have challenged that disposal. On tab 40 of the authorities bundle, the Whitstable case, my lords and my lady will see paragraph 1 was a challenge to a resolution to dispose of property and a contract for sale. So in other words, those two stages prior to disposal. So section 128 didn't bite. So it was the stages under the structure deed decision which 128 didn't bite on. So they were able to challenge those prior decisions just before disposal. Section 10, we've migrated really from section 164 through to section 10. I do need to remind the court that the judge below was inclined to think that the appropriate provision was in fact section 164 of the Public Health Act 1875 rather than section 10. And the reason for that was the minutes from, sorry, not the minutes, the bylaws from 1971, which referred specifically to that provision, and they're at tab 48, page 339. So in the course of,
Sorry, it's 164.
so page, yeah, so
It's in the
so section 164 is tab 1 of the authorities bundle, and it's important to have regard specifically to that. It says any local authority may purchase or take on lease, lay out, plant, improve and maintain lands for the purpose of being used as public walks or pleasure grounds, and may support or contribute to the support of public walks or pleasure grounds provided by any person whomsoever. That's then in tab 12 in the Attorney General and Sunderland Corporation case regarded as establishing the statutory trust, and then the statutes then come to incorporate it as a public trust, as you've seen in the 1972 Act. So
in the 1972, 164 ends up as what? A section in the 72 Act?
no, so 164 remains on the books now, so that's
Yes.
still good law.
Oh, you mean the reference to a
it comes
trust?
to be treated as a trust by virtue of the decision of.
Well, we haven't looked at all today at section 164.
No, we haven't. That's why I'm ensuring we don't drift off too much
No,
into
well, all
section
right.
10
So
alone.
we better. Any local authority may purchase or take on lease, lay out, plant, improve, and maintain lands for the purpose of being used, and so on, and may support or contribute to the support of works by anyone else, provided by anyone else. Well, this obviously, I imagine this comes into the first half of that provision. Any local authority may purchase,
Yes, so the judge was inclined to think
improve,
that.
and maintain lands for use as a public walks or pleasure ground.
But isn't the point?
Same point, though, isn't it?
But isn't the point that although the 1875 Act doesn't refer to a trust, because of Sunderland and Finsbury Park,
Yeah.
the trust applies.
Correct. So
The trust is still linked to the ownership of the land, isn't it?
I'm not disputing that.
Oh,
at this
forgive me.
juncture.
I thought that
I'm just making sure we understand.
We
that
understand where
we're not
we're
a
at.
pure Section 10 case
Yes.
necessarily, particularly in
I
light
see.
of the evidence in the bylaws, which I've just given the reference for, being that those bylaws were made under.
But it doesn't matter.
No,
In
but,
all the case
we've
law,
got it in mind. Yes.
recent case law, they've been treated as both establishing trusts.
Yes, I follow. And
in
as you
terms
rightly
of-
say, that's what the section does. Yes.
I'm just making sure we don't
No,
just
it's
treat it as
helpful,
Section 10 because
No,
that's not how
I
the
think
judge
it's very
treated it. Section 131, I omitted to refer to. Essentially, I say that just refers back to Section 123, 2A and 2B, Section 131 of the Local Government Act. It doesn't add any further protections, etc.
I see.
The genie back in the bottle point,
Oh, yes.
in my submission, yes, it is difficult, and I don't shrink from that. It's supposed to be difficult. As my Lord Justice Hickinbottom pointed out, up until these statutory provisions, there was no way of putting the genie back in the bottle whatsoever. But there are now some workarounds that could be used. But that doesn't necessarily, well, it doesn't, in my submission, affect the construction of the statute.
Well, we're just past 4:30 now. So unless there's something of great importance, I think that brings your submissions in reply to an end.
I'm grateful, man.
Thank you very much indeed. Thank you both for your submissions. We'll reserve our judgments. They'll be circulated to you in draft in the usual way, and we'd be grateful for any typographical or factual errors of that sort, but as you know, it's not an opportunity to re-argue the case. We would hope that you could agree the terms of an order disposing of the appeal, but if there's any difference between you, if you wouldn't mind making your submissions in writing to us, and we'll decide that on the papers. The judgments, once finalised, will be handed down remotely in accordance with the usual practice, simply by being sent to you and then being posted on the relevant website, so there won't be any further hearing. But thank you all very much.
Oh, you're here. Sorry, I'm just emailing you. Ah, no problem at all. Right, good. Let me just pack these things out.
No rush at all. I've always said be here for 4 that way and never leave.
Fair enough.
Anyway,
Let's have a
someone
look.
there for you.
Yeah, great. I know, well, you're supposed to be so careful about papers these days, aren't you? So it's actually quite helpful of you.
Sure, yeah, I've washed my hands like 15 times today, so it's,
No, I wasn't meaning that. I mean,
no, I'm just saying,
data
well,
protection
it's
and all that.
essentially reassurance, really.
Are you all a bit run off your feet at the moment in chambers, or is it?
I think today at the moment it's not too bad, but I think tomorrow onwards, because we essentially lose the remainder of the clerk's room, and it's just me, Rudy and Remy.
You're going to be a bit.
Yeah, I think that would be testing, but just take each day as it comes, really.
Okay, I'll try and stay off your back.
No, that's fine. If you need stuff done, you need stuff done.
I know, but I sent to ask Ben if he could print a couple of things off for me this morning. You phoned me up. It's like, I've got too much to do.
Yeah.
You're back off up north, Killian, or?
Yeah.
Are you?
Those instructing me are watching.
Oh, are they packing up? Right.
Well, they just said that they can hear us chat. What's your chamber's policy at the moment in terms of are you allowed in or?
Well, we were. I think from tomorrow you're supposed to not, unless obviously it's essential, which you could be. But yeah, That's the idea, isn't it? Yeah. We're allowed in. Yeah. But that's basically been it for 7 months. Is try not to come in.
It starts tomorrow, doesn't it?
Mm?
It starts tomorrow.
The next one, yeah. I mean, it just seems like it's more symbolic this time. There's no actual rules that you're not about. You know, you're not.
It's more the restaurants closing and things like that.
It is, yeah. That's true. Yeah, I'm going off to dinner tonight.
You're not allowed to go on holiday.
Oh yes, that's well.
Well,
That's generally applicable to me anyway. So.
Is that everything?
That is brilliant. Thank you, Tom.
Lovely.
Uh,
I might be a touch late.
Thank
no,
you
it's
for
no
those
problem. I've got
questions.
to talk to the clients. and so on.
Pardon?
Thank you, sorry.
Thanks.
Shall I just
Oh,
leave
right,
it
that's
to you?
Yeah.
Yes, thank you.
Thanks. All right.
That's a bit
See you.
different
Speak
from
call
last
next then, please.
yeah, thanks. Are you Alex's pupil by any chance?
Sorry?
Are you Alex's pupil?
No, I'm Alex's clerk. I'm the
Oh.
one that sent you the authorities bundle, Thomas.
Oh, yeah, yeah.
So-
Good to meet you.
My days of going through undergraduate law, masters, and LPC are over now. So
Right. Yeah, I should have told you. My client told me that.